Okay, I think I'm going to make a start, Joe, if that's okay. No, if we could go back to the first slide. Okay. Right, good afternoon, and thank you for attending this webinar on often overlooked doctrines, in particular the presumption against double portions, secret trusts, donatio mortis causa, and the rule in Strong and Bird. These are largely anomalous and imperfect doctrines. However, in the right circumstances, they may found a successful course of action, or at least provide some basis for or leverage in pre-action negotiations or negotiations otherwise. It's therefore worth having these doctrines in mind during initial consultations with clients. Obviously, it's difficult to gauge what everybody's practice is in the audience, and it seems to me that these doctrines will either be unknown or rarely used by most practitioners. So owing to time, I'm going to provide only an introduction to or refresher of these on these four doctrines. Of course, if one of these issues should arise in your practice, you should give more detailed consideration to the legal and evidential requirements. And I should also emphasize that this is not an exhaustive survey by any means for the obscure doctrines which may be relevant in a given case. So Joe, if we could go to the first slide. Turning first to the presumption against double portions. In fact, as you can see from the slide, this is merely part of the wider equitable presumption of satisfaction, which covers three distinct presumptions, namely the presumption of satisfaction of a debt by a legacy, the presumption of satisfaction of a legacy by a legacy, and the presumption against double portions, on which we're going to concentrate. And I'm going to concentrate on that really rather because the other two presumptions tend to limit rather than potentially increase the entitlement of a beneficiary, and so are not as useful in the armoury of contentious practitioners, which may make up the most of the audience, I think, but I don't know for sure. Joe, if we could turn to the next slide. Indeed, I'm going to be even more restrictive in my coverage of the presumptions, since I'm going to focus on only one of the sub-presumptions, or the sub-sub-presumptions, if you want to look at it that way, into which the presumption or sub-presumption against double portions itself subdivides. And you'll see that those three sub-presumptions are set out under the first bullet point. And what we're going to focus on is the presumption of satisfaction of a legacy by a portion, sometimes called ademption of a legacy by a portion, since that's the actual effect of the doctrine applying. It seems to me that that of the three sub-presumptions is the most useful in the armoury of a contentious practitioner, and moreover the other two sub-presumptions, which concern so-called portion debts, have, as I'm sure we'll all be able to give witness, been rare since the Married Women's Property Act of 1882. The first point to make then about the subcategory on which we're going to focus is that it's akin to a rule of construction, in that it's based on the presumed intention of the testator, namely that a parent would wish to treat his children fairly and would not wish to make provision for one of his children twice over at the expense of the other children. The initial burden in raising the presumption is on the claimant to establish these three things. Firstly, that the testator was the parent or in loco parentis to the defendant. Secondly, that the testator gave a legacy or a share of residue to the defendant by will, which is assumed to be a portion. And thirdly, that the testator subsequently during his lifetime, that's subsequent to the will, provides a portion for the defendant. The classic example, therefore, is a gift of residue to 2 or 3 children, but with the testator subsequently making a substantial portion gift to 1 child. In those circumstances, the court will prima facie lean against the double portion so as to achieve equality amongst the children, or equality so far as possible. However, it should be noted, obviously I've referred to the defendant being a child, or in loco parentis to that defendant, sorry, the testator being. However, it should be noted the doctrine will not work so as to benefit a stranger. So if the testator divides his residue between his 2 sons A and B, and also a stranger C, a friend, for example, And after making his will, he gives a portion of, say, £5,000 to A, and the residue is £30,000. Then the doctrine will not be applied in favour of C, who will just receive the £10,000 third share, but it will be applied in favour of B, with the result that B will receive 15,000 and A will receive only 5,000, having received the other 5,000 into vivos. Joe, if we could just turn to the next slide. Now, the real question in practice will be whether the subsequent gift is properly classified as a portion. And for those who don't know anything about this doctrine, you may well have heard me kind of babbling on about portions for a while now and not really knowing what that meant. Well, Mr. Justice Lindsay, in the case of Re Cameron, which is really the first kind of modern decision on this doctrine and something that should be read, along with some subsequent decisions, in particular by His Honour Judge Behrens, if someone's involved in a portions case. Mr. Justice Lindsay, in that case, said that a portion, and this is correct, is very broadly speaking a gift intended to set up a child in life or to make substantial provision for him or her. Whether the gift is a portion will be a question of fact to be considered in the circumstances of every case. In very different times when this doctrine was more prevalent, purchasing entry into professions, such as entry into the Middle Temple in a case, commissions in the army, or capital to set up in business have been held to be portions. Nowadays, the purchase of a residential property, which can now be a portion but didn't used to be able to be a portion, may well be the paradigm example. Now, the presumption, if you satisfy those three requirements, is raised, but like most presumptions, it's rebuttable, and it's rebuttable by either intrinsic or extrinsic evidence. Intrinsic evidence comes in the form of substantial differences in the limitations contained in the two portions, or the fact that the portions are not of the same type. So a legacy of a sum of money is not deemed by a later gift into vivos of stock in trade, unless the testator puts a value on that stock in trade when making the gift so that it can be regarded as a gift of money. So if the stock in trade is given and said, going back to our earlier example, this is £5,000 of your inheritance, then that may be sufficient. Extrinsic evidence to rebut the presumption comes in the form of evidence of the testator's declarations of intention. And such declarations have always been admissible in regard to equitable presumptions, and this equitable presumption in particular. Of course, now since the Administration of Justice Act 1982, there's kind of little difference between that and a rule of construction as to which this is akin, but different primarily for that reason, as I said earlier. So although, although evidence of what the testator did or did not intend when making the will be of relevance generally, obviously what we're really concerned with is evidence of intention at the time of the subsequent gift. That's certainly the most important in terms of rebuttal. I should say that the claimant's evidence alone may be sufficient, but it does seem to me that it'd have to be very impressive evidence in a particular case, certainly if there wasn't documentary evidence to support the assertion. Joe, if we could turn to the next slide. Joe, if we could just turn to the next slide. Thank you. So turning next to secret trusts. Under the doctrine of secret trusts, a primary donee under a will may be compelled to hold the gift he receives under the will for a secondary donee under an arrangement taking effect outside the will. Now, secret trusts are divided into two categories, either fully secret trusts or half secret trusts, and that's important in terms of the requirements I'll get to in a moment. As may be obvious, a fully secret trust is where the primary donee takes beneficially on the face of the will and the trust is not disclosed, so it's a legacy or a gift to X with nothing else said. A half-secret trust, however, mentions the existence of the trust but not its terms in the will, so it'd be a gift to X on trust, but without saying what those trusts are. So in order to establish either a fully secret trust or a half-secret trust, the secondary donee, so the beneficiary under the secret trust, must establish the following. Firstly, an intention on the part of the testator to subject the primary donee to an obligation in favour of the secondary donee. Secondly, communication of the intention to the primary donee during the testator's lifetime. And third, acceptance of that obligation by the primary donee, either expressly or by implication. So we have intention, communication, and acceptance. Now, obviously, in terms of intention, the intention to create a trust in respect of a half-secret trust will be apparent from the will itself, so it's slightly easier to establish that element. However, in the case of a fully secret trust, obviously there'll be nothing in the will, and it will be for the secondary donee to prove that outright. The applicable standard is the civil standard, but often the secondary donee will have very little information on which to base its claim. And also, often such claims are grounded in fraud and allegations of fraud. And so again, while that will be on the civil standard, obviously the court requires the clearest of proof before making out such allegations. And as practitioners, we require a minimum standard of evidence to really plead or put forward such an allegation. Now, they're the three requirements for all, for both half-secret and fully secret trusts, and you'll see on the slide that there are some additional requirements if you want to establish a half-secret trust, and they're namely that about the communication, and namely that the communication was no later than the time when the will was executed, and secondly, in strict compliance with the requirements of the will. And they're both to avoid giving, as the cases say, the go-by to the Wills Act, simply because it's referenced in the will. So, for example, in terms of strict requirements, if the trust is stated to be a gift to 4 people as trustees, then the communication, at least by the time the will is executed, needs to have been made to all 4 trustees. Now, there is some difficulty in classifying secret trusts as either express or constructive, and that's a controversy which is largely unresolved, I believe, although probably more express than constructive. This is important not least because of the formalities required by Section 53 of the Law of Property Act if the trust is a trust of land or including land. In any event, it's arguable that the secret trust of land should be enforceable anyway, because on the simple ground that a statute cannot be used as an instrument of fraud. But do remember that there is an ongoing debate about whether such cases will always result in the trust declared without applying the formalities, or whether it will be a resulting trust back to the testator's estate, which obviously will defeat the purpose. There are a number of other quirks concerning, for example, the witnessing of a will by primary or secondary donees. Put shortly, the primary donee can be a witness if it's a half-secret trust, but not a fully secret trust, and the secondary donees obviously don't, there's no restriction. There are some other quirks, for example, about the death of primary and secondary donees during the testator's lifetime, but I don't really have time to go into all of those today. So, Joe, if we could turn to the next slide. A donatio mortis causa is neither an inter vivos gift nor a gift by will. It has its own distinct requirements, and I've put those out on the slide. So I'm just going to go through each of those and make some comment. So firstly, it must be intended by the donor to be conditional on his own death. In other words, as Mr. Justice Farwell put it in Reed Craven's estates, there must be a clear intention to give, but to give only if the donor dies. Whereas if the donor does not die, then the gift is not to take effect, and the donor is to have it back the subject matter of the gift. So that means there can be no donatio if the donor intends to make an immediate gift. If such an intention does not meet the requirements for an inter vivos gift, it would fail, unless it could be saved by, for example, the rule in Strong and Bird, to which I'll turn shortly. Equally, there can be no donatio if the donor intends to make a gift by will, although usually such an attempt would fail, it seems to me, not because there was an express intention to make a gift by will, but rather because there was no intention to part with dominion at the time of forming the intention, because obviously it was a testamentary ambulatory intention. Secondly, it must be made by the donor in contemplation of death. It's not sufficient for the donor to contemplate the possibility of death at some vague time in the future, which is, in my experience, a very common feature of cases where I'm asked to advise on donatio mortis causa. What's required is that the donor must contemplate impending death or death within the near future. And the strictness with which this requirement and all the requirements of this anomalous doctrine will be interpreted was highlighted by the relatively recent decision of the Court of Appeal in King and Chiltern Dog Rescue, where an elderly donor had handed over the deeds to her house to her nephew some months before death, but as Lord Justice Jackson put it in the Court of Appeal, did not have reason to anticipate death in the near future from a known cause. The third requirement, before death, the donor must part with dominion over the subject matter of the donatio. And two elements are required for this. First, obviously, as you can see, it separates into two elements. Firstly, the donor's intention to part with dominion, and secondly, sufficient delivery or transfer of the subject matter of the gift or of something representing it to the donee. It's essential that the delivery is effected during the donor's lifetime. So there was no donatio mortis causa in the case of Bunham Markham, where a donor wrote the donee's name on an envelope, gave it to a third party, and requested that it be delivered to the donee after death. In the case of a chattel in particular, there must be actual delivery. These are just general requirements in terms of perfecting gifts, but there must be actual delivery either of the chattel itself or as the means of obtaining the chattel, such as the key to a car, or in the older cases when people were held kind of strong boxes, keys to that box, or perhaps nowadays was a key to a safe deposit box. These requirements for the delivery of a chattel apply equally to the delivery of a chosen action. So bearer bonds, whoever still has those, have to be delivered, or the means of obtaining them has to be delivered. The fourth requirement on the slide is that the subject matter must be capable of passing by donatio. Now, in general, pure personality is capable of being the subject matter of a donatio. There are some additional considerations in respect of checks and promissory notes and company shares. It is also now relatively well established that land can be the subject matter of a donatio. As with the other two doctrines, the burden of proving these requirements is on the donee. The standard of proof, again, is the normal civil standard, but the court will subject the evidence to strict scrutiny so as to provide some safeguard in lieu of the safeguards imposed by the Wills Act, which obviously this is getting around. Even if the requirements of the donatio on the slide are established, it should be remembered, as I said at the outset, that a donatio is revocable until death. And importantly, that this revocation is automatic if the donor recovers from the illness which was contemplated at the time of making the gift. So Joe, if we could turn to the next slide. So finally, I'm going to go through the basics of the rule in Strong and Bird. Now, the case of Strong and Bird was decided in the late 19th century, and it concerned forgiveness of a debt rather than a gift. In that case, B, Bird, borrowed £1,100 from his stepmother, and the stepmother was living with B and paying him board and rent. They agreed that B should repay the loan by way of deductions of £100 from the board and rent for 11 quarters. The stepmother duly deducted £100 from her next 2 quarterly payments, but then she refused to make any further deductions, and she expressly forgave the debt. She then continued to make full quarterly payments of board until her death, and by her will she appointed B as her sole executor, and he proved the will. Now, the problem here was that the forgiveness of the debt was not valid at law, since it wasn't supported by valuable consideration or a deed. As a kind of odd quirk, the debt was nevertheless released at law once the bird became the executor, because he couldn't sue himself. But the way that situation was thought to kind of pan out in those days was that he would nevertheless be liable to account to the estate in equity. However, the Master of the Rolls held that Bird was not liable to account to the estate in equity because his stepmother had a continuing intention to forgive him the balance of the loan. And you might think that the reasoning of that is somewhat suspect, but nevertheless, there it is, and it's been followed and indeed enhanced. So in Rees-Stewart, the rule was extended to the situation with which most contentious practitioners are probably most likely to be concerned today, namely to the perfection of an imperfect gift made by the deceased during his lifetime. So Joe, if we could just go to the next slide. In Rees-Stewart, the deceased, just stating the facts very briefly, bought 3 bearer bonds through his brokers a few days before his death. He then handed an envelope to his wife, which contained the broker's letter recording the purchase of the bonds. And he said to his wife, "I bought these bonds for you." The bonds were not, however, delivered themselves to the wife before the deceased's death, and so she didn't have any title. The wife, in equity, the wife was one of the deceased's proving executors, and Mr. Justice Neville, who heard the case, held that the wife was entitled to the bonds under the rule in Strong and Bird, which he summarised as follows, and I think it's worth me just briefly reading through that as a kind of main statement of the law. So the decision, and that's referring to Strong and Bird, is, as I understand it, to the following effect: that where a testator has expressed the intention of making a gift of personal estate, and I just pause there for a second to say that the rule now also applies to real estate, continuing, belonging to him to one who upon his death becomes his executor, the intention continuing unchanged, the executor is entitled to hold the property for his own benefit. The reasoning by which this conclusion is reached is of a double character. First, that the vesting of the property in the executor at the testator's death completes the imperfect gift made in the lifetime. And secondly, that the intention of the testator to give the beneficial interest to the executor is sufficient to countervail the equity of the beneficiaries under the will, the testator having vested the legal estate in the executor. Now, the reasoning of this decision, and indeed Strong and Bird, may arguably be unconvincing, since the property vests in a fiduciary capacity rather than beneficially as executor. And perhaps this is an example of hard cases making bad law. But so far as I'm aware, it's never been doubted at first instance, not that it comes up all that often, but it's never been doubted at first instance, or indeed when it's been before the Court of Appeal. In any event, from that quote, what we can see are the 3 requirements that need to be proved. And that's firstly that the deceased during his lifetime had a present intention of forgiving a debt or making a gift of particular property, as the case may be. Secondly, that this intention continues unchanged until the deceased's death. And thirdly, that on the deceased's death, the subject matter of the gift becomes vested in the donee. Now, the first point to make about that is that it's not enough that the deceased merely intends or promises to make a gift on a future occasion. Therefore, it's insufficient that the deceased's intention is testamentary. The requirement for a continuing intention may be disproved by the subsequent conduct of the donor. For example, if they took security from the debtor, or in the case of gifts, if they actually lended the subject matter of the gift to the donee, such as lending the car or allowing someone, for example, to reside in the property that had been the subject matter of the gift, but on express terms, perhaps some payment of rent or a peppercorn rent. The requirement for vesting will clearly be satisfied if the donee is appointed the deceased's executor and takes a grant of probate. In Strong and Bird itself, Bird was the sole executor, and in Rees-Stewart, the wife was an executrix, but one of a number. There is, however, some controversy about whether taking a grant of letters of administration suffices. Obviously, the property does vest in that person, but is it enough given that the deceased didn't make them the personal representative expressly so as to vest that property at the date of death? Now, it was held to be sufficient in a case called Re James, but it was doubted in a case called Re Gonin. For my part, I agree with the comments of Mr. Justice Walton in Re Gonin, but one cannot rule out the possibility of the court following the decision in Re James in an appropriate case. Joe, if we could turn to the next slide. That's something of a whistle-stop tour through these four discrete doctrines, which are often overlooked by practitioners, some of which, in particular the presumption against double portions and the doctrine of secret trusts, are actually rather complex and cannot be done justice in the context of this short webinar. Nevertheless, I do hope that I've provided you all with a useful introduction to or refresher on these topics. As I said at the outset, they are anomalous and imperfect doctrines, which modern courts may be reluctant to uphold unless the case is on all fours. Nevertheless, I think it's important to bear them in mind in initial consultations with clients, because they may at the very least be useful in creating or providing leverage in negotiations, and I've had some limited success in that regard. For example, one can see how an arguable double portions claim might assist in a mediation or in negotiations when combined with a borderline claim, as arguably they now largely are, for reasonable financial provision by an adult child. Okay, that brings me to the end of the presentation. I received two questions. Questions before this webinar. One was quite specific and really about a very specific case, and largely, although it did involve secret trust, concerned the conflict of laws and to some element Spanish tax. And that's, I think, out with the real scope of this webinar. But the other was about the making of testamentary instruments after the relevant portion gift. Now, in response to that, I'd say that first, the presumption against double portions will not operate in respect to the gift made before the will. As I've said, this is because the presumption concerns the testator's intention, and clearly this presumption will not override the actual act of executing a will. The presumption may, however, apply if the testator confirms the will in a later codicil, it's worth noting, but it will be relevant, but the fact of the remaking will be a relevant consideration on the issue of rebuttal of the presumption. Okay, I don't think there are any specific questions that have been asked, so I hope that was useful, perhaps provided some kind of weird distraction from daily life at the moment, and yeah, I hope to see all of you or some of you soon in better times. So thank you very much, and good day.